Hi, I'm Peter Grant, owner of GFP. All I wanted to do was expand my personal 3-hole golf course to a full 9-hole course here at Twin Lakes. My fellow cottagers are up in arms about my personal project and relations with Premier Mike Harris. Next thing I know, they alerted the Toronto Star and an article was published about me defaming my character and insinuating I was using my political ties to get my way. I will not stand for this slander.
Hi, I'm Bill Schiller. I'm a reporter for Toronto Star, and I'm just trying to do my job. I wrote my article based on the information I was given and a quote from a local resident, Lori Clark. And now, myself and affiliates of the Star are being sued for defamation.
Hi, I'm Dr. Lori Clark. I'm neighbors with Peter Grant at Twin Lakes. I'm among the other cottage owners who are against Grant expanding his personal golf course, but our protests and concerns for the environment don't seem to matter. Like I told the Toronto Star, everyone thinks that it's a done deal because of Grant's influence, but most of all his ties to Premier Mike Harris.
Ladies and gentlemen of the court, we have already heard the evidence, examination, and cross-examination from both the plaintiff and the defendant in the defamation case against Toronto Star and Mr. Schiller. I remind you today that Dr. Clark is not present because she has already settled with Mr. Grant outside of this court. I will now call upon Mr. Grant to briefly outline his case before the defense has the opportunity to outline theirs. Mr. Grant, please present your case.
Thank you, Your Honor. As an individual, businessman, and citizen of this country, I have a right for my privacy and reputation to be protected. The Toronto Star published an article about my proposal to expand my personal golf course and painted me in a horrible light. Most awful, however, by emphasizing my charitable donations to the Conservative Party over the years, in conjunction with Dr. Clark's statement about my ties to Mike Harris. This article accuses me of improperly using my influence to obtain government favors. I take this allegation very seriously, which is why we are here today.
Toronto Star, your defense please.
Your Honor, we respectfully disagree with Mr. Grant's claims. The article aired the real and legitimate concerns of local residents without any allegations of indecency against Mr. Grant. I, reporter Bill Schiller, examined records of Elections Ontario, met with several local residents, spoke with Ministry of Natural Resources representatives, and tried to interview Mr. Grant on several occasions to get his side of the story. But he repeatedly refused me and eventually threatened me with this lawsuit. Your Honor, we ask that you consider recent English jurisprudence and expand qualified privilege defense based on the concept of public interest responsible journalism.
The defense does not apply in these circumstances because the story was locally focused and had a very bad tone. Jury members, you are open to decide if the done deal statement was a fact or a statement of opinion. The key question you must answer is if the reporter honestly believed in the defamatory statements. Based on this decisions, please deliberate and conclude if the Toronto Star has the defenses of fair comment or truth.
Your Honor, we as the jury reject these defenses and find the Toronto Star liable. We award the plaintiffs general, aggravated, and punitive damages totaling $1,475,000.
Your Honor, given the recent appeal case which recognized a new defense of responsible journalism, we the defendants appeal the 2001 jury verdict on both liability and quantum of damages.
I affirm the new responsible journalism defense, given that the article should have been found in the public's interest because it was about potential government coercion. I conclude that the jury's instructions were flawed, the trial judge erred in not leaving this defense with the jury, and they may have found malice on improper grounds, thus defeating fair comment. On this basis, the Court of Appeal orders a new trial.
The 2001 case of Peter Grant suing the Toronto Star has come to the Supreme Court of Canada because Mr. Grant has appealed to this court to reinstate the original jury verdict. The Toronto Star has in turn cross-appealed, asking the court to apply the new defense and dismiss Mr. Grant's section. Now that you've heard the facts, let me outlay the issues. As the common law stands, there is an uneven balance between the protection of one's reputation and the freedom of expression, with favor leaning towards reputation. The media and its affiliates are not enabled to produce accurate and responsible communication out of fear of being sued for libel. This impedes against the public's right to have access to information that concerns them. The issue is multifaceted. However, because it is not as simple to say, let's change the law, in order to strengthen factual statements published in the public interest, several questions arise. 1. Should the common law include a defense that upholds the freedom of expression and reporting on matters of public interest? Number 2. If yes, what would this entail? Number 3. If so, what procedures should apply? What are the roles of the judge and jury? Number 4. What does this ruling mean for Mr. Grant and the Toronto Star case? After much deliberation and review of the facts, issues, and international jurisprudence, I have come to the conclusion that the common law should be modified to recognize a defense of responsible communication on matters of public interest. Right now, the law is too limiting and unjustly favors protection of one's reputation at the risk of impeding free expression. So, what is public interest? It is enough that some segment of the community would have true interest in receiving information on the subject. Additionally, in a defamation suit, a judge will determine whether or not a matter is in public interest, and a jury will determine if adequate defense is upheld. The defenses being fair comment, justification, and now responsible communication. What does this responsible communication entail? It will apply where the publication is on a matter of public interest, the publisher was diligent in trying to verify the allegation, keeping in mind the severity of it, the public importance on the matter, the urgency, the status and reliability of the source, whether the plaintiff's side of the story was sought and accurately reported, whether the inclusion of the defamatory statement was justifiable, whether the statement's public interest lay in the fact that it was made rather than its truth, and other relevant circumstances. So, what does this mean for Grant and the Toronto Star? In the original trial court, the judge should have found the matter to be in the public interest rather than local. Moreover, the jury should then have all 3 defenses available to them and have been instructed correctly. The done deal remark could have been seen as a statement of a fact, meaning that the government's approval was already secure, raising the defense of responsible communication on a matter of public interest. It could have been seen as a statement of opinion about the government approval not having come to pass yet, raising the defense of fair comment. They were left open to infer that Mr. Schiller had adopted Clark's statement as his own and were greatly misled in the due diligence he applied in an attempt to get Mr. Grant's side of the story and verify the statement. Taking all of these factors into account and the modification of the law, I proclaim that a new trial is required.